We have almost come to an end of this chapter. In today's session, we will discuss communication of offer and acceptance. I had an option to club communication of special terms also, but then there are two case laws and the concept is very different from what we are studying. So now I will only discuss communication of offer and acceptance. In my next session, I will discuss with you a very small but interesting part, communication of special terms, and we will also discuss two case laws. What kind of questions can be asked from from this part? Mostly it will be case-based question only. I don't think a theory question will be asked. Although you will be expected to write the theory when the case-based is asked, but yes, a separate theory question wherein you are expected to explain the entire concept, that will not be asked in the exam. So expect case-based questions, situation-based question on this part. Do we need to remember each and every section that we are going to study now? No, just remember section 4 and 5. Okay, so just two sections that you need to learn for this concept. Now, I will give you a format and you can use that format to convert any question. Okay, convert that into the format which I'm going to share with you. If you are able to convert the question into that format, you will never go wrong. Okay, that the format which I'm going to share with you is so exhaustive that you will be able to answer any question that is asked in the exam. So for us, understanding the format is very important. Now, communication of offer and acceptance. See, when the parties are sitting face to face, there's no gap in communication. I gave the offer, you listened to it, you heard it, you had knowledge of that offer, then you can choose to either accept or reject it. If you accept, a valid contract will come into existence. If you reject my offer, offer will lapse. So when the parties are sitting face to face, acceptance can be immediate. There is no gap in communication. But when the parties are sitting at distant places, like the person who's giving the offer is in Mumbai, and the person to whom the offer is given, offeree, he is in Delhi, and they are communicating via letters. Ma'am, who communicates via letters these days? It is so easy to email that person or just call or just to send a WhatsApp message. It's so convenient that way. But imagine, students, we are studying an act which was enforced in 1872. So the provisions still remain. Do people really communicate via letters? Now, you must have studied in the Companies Act that application for shares is like an offer. The company allots the shares, so they give a letter of allotment. Not everyone has an email, no? So for people who have not provided their email ID, the company still sends letters. So yes, there is a possibility of communication via letters. Or I am old fashioned. I don't believe in these email and other electronic mediums of communication. I feel letter is more personal. So we cannot just ignore the letters. Even today, we have the Indian Post which delivers letters to various places. So these provisions still find a place in the Contract Act. So when the parties are at distant places and they are communicating via letters, there can be a gap in communication. So I wrote the letter of offer. I posted that. It will take around 3 to 4 days, sometimes 5 to 7 days, depending on your location. So I posted the letter today. It will reach you after 5 days. You had gone out of station. So you came home, you read the letter, you knew about the offer, you wrote the letter of acceptance. That will take around 5 to 7 days to reach. There is a gap in communication. Because there is a gap in communication, we need rules which will tell us when is the offer communicated. By what date can we say that the offer is communicated? When can we assume that acceptance is communicated and a contract is entered? So we need rules which will help us to determine as to when parties are bound, when is the contract entered by them. Those rules are covered in section 4 and 5. When the parties, contracting parties, they are sitting face to face. So there's no problem in communication because there is an immediate communication of offer and acceptance, yes. The difficulty arises when the contracting parties are at a distance from each other. One is in Mumbai, other is in Delhi. They are communicating via post. We will also study communication via telephone because subsequently telephones were also introduced. Email this is not there in the act, but yes, we are going to study that because it is given in your study material. So basically, the act talks about communication via post, but we will also discuss telephone and email for examples. In such case, it is important for us to know the exact time when the offer or acceptance is made or complete, because this time will determine whether a contract is formed or not, and when a contract is formed. What on what date is the contract entered? So we want to find that particular day. So we have rules for them. The rules are laid in section 4 and 5. Okay, so section 4 and section 5, they shall apply. Okay. Now, first let me discuss the format. I'm not interested in this theory because you will really love the format that I'm going to discuss with you. Why don't you write along with me? Yes. So give the heading in your notebook as communication. Write down communication of offer and acceptance. Introduction, we have already covered that this concept is useful when the parties are at distant places. So please write along with me. I will also dictate how I am writing, so pay attention to that also. X offered to sell his flat to Y for 50 lakh rupees. Okay, X offered to sell his flat to Y for 50 lakhs. He wrote the letter of offer and posted it on 5th of April. See how I'm writing. He wrote and posted the letter on 5th of April. It reached Y on 7th April. Y wrote his letter of acceptance and posted his letter on 8th of April, which reached X on 10th of April. Did you notice how I wrote the dates? Pay attention. X posted the letter on 5th of April and the offer letter was received by Y on 7th. Y read the letter, he wrote his letter of acceptance, posted it on 8th, which reached X on 10th. So these dates relate to offer and the below relate to acceptance. I repeat, X posted the letter of offer on 5th, it reached Y on 7th, Y posted his letter of acceptance on 8th and it reached X on 10th. Wrote this much? Let's continue. When can we say that the offer is communicated? When is communication of offer complete? We are discussing about offer. So pay attention to the dates related to offer. When can you say that the offer is communicated? Offer is communicated on 7th April. That is when it comes to the knowledge of Y. So the date is 7th of April. Y read the letter of offer on 7th April. He came to know about the offer on 7th April. So X can easily conclude that my offer is communicated on 7th. So communication of offer is complete when it comes to the knowledge of offeree. Let me give you a variation over here. Let's say that Y received the letter on 7th, but he was out of station. He came home and read the letter on 8th April. When can you say that the offer is communicated? When the letter reached him or when he read the letter? Yes, merely receiving the letter is not important. When he reads the letter, when he comes to know what is the meaning of knowledge, when he comes to know about the offer, when he reads the letter, that is the time when offer is communicated. So for us, the date will be 8th in that case. Okay? So that was just a variation. Communication of offer is complete when it comes to the knowledge. What is the meaning of knowledge? That is when the offeree reads the letter. What is the key word over here? He reads the letter. Merely receiving it is not important. When he reads the letter, that is the time we can say that offer is communicated. Now he came to know about the offer. He wants to accept the offer. So communication of, write down, communication of acceptance. Okay, he came to know about the offer. Now he wants to accept it. So when can we say that communication of acceptance is complete? Now there are two dates over here. I will discuss it and then you can write it. Communication of acceptance as against the offerer and as against the offeree. Why two separate dates? I will discuss with you. Now, X offered to sell his flat to Y. He wrote a letter on 5th, posted it, and it reached Y on 7th. Y read it on 7th. Offer is communicated on 7th. Y wrote a letter of acceptance. He posted it. He put that in the red post box. Yes. He posted the letter. As soon as he posts it, now he cannot remove it back. He cannot put his hand in that post box and remove it back. It is beyond his reach now. So as soon as he posts the letter, X, for you, the offer is accepted, contract is made. Wait for the letter to reach you. Now, when can we say that communication of acceptance is complete as against the offerer X? For the offerer, acceptance is made as soon as Y puts the letter in the course of transmission. It means he posts the letter. X, for you, a contract is made, your offer is accepted. Don't give that offer to someone else now. You are now bound by the contract. Your letter of acceptance is posted. Just wait for 2 days to reach it. In 2 days, it will reach you. But for you, the offer is accepted. So in this case, as against the offerer, the acceptance is complete on 8th of April. That is when X posts the letter. Let me write that for you so that later on you have no doubt or confusion. As soon as letter of acceptance is posted by Y. The words which are used in the act is when the letter is put in the course of transmission. It is put in the course of transit. It is posted. Wait, it will reach you in some time. Now, for X, the offer is accepted on 8th. It means for X, the contract is made on 8th. X, you are now bound by the contract. Don't give that offer to someone else. Y has posted the letter of acceptance. For Y, the acceptance is complete on 10th. That is when the letter of acceptance reaches X. All the dates go cross. Did you notice? So for Y, as against the offeree, Y, the communication is complete on 10th of April. That is when the letter reaches X. So communication is complete as soon as the letter of acceptance comes to the knowledge of, that is when he knows about it, knowledge of X. Okay. Why two separate dates? We will discuss in some time. Now, for X, contract is made on, you tell me. That is offer is accepted. You can write his offer, so it'll be more clear. His offer is accepted. On which date? For X, the contract is made on 8th of April. Yes. And for Y, contract is made on, that is, his acceptance is complete. Contract is made on 10th of April. Very good. So this is the interpretation. Okay. Let us discuss again. So X posted the letter of offer on 5th. It reached Y on 7th. Y posts the letter on 8th. It reached X on 10th. When is the offer communicated? Offer is communicated on 7th April. That is when Y comes to know about the offer. When is acceptance complete as against X? When can we say that a contract is made for X? When Y posts the letter. It is put in the course of transmission. So for X, contract is made on 8th April. When can we say that a contract is made for Y? For Y, the contract is made on 10th. That is when the letter reaches X. Now let's say that X gave the offer and then he realized, oh God, I didn't want to give the offer. He wants to call back his offer. Calling back is known as revocation. Y gave his acceptance, but then he realized that, oh, I didn't want to give my acceptance. He wants to call it back. Calling back is known as revocation. So let us discuss revocation of offer and acceptance. Revocation means to call back. X gave an offer to Y. He posted the letter of offer on 5th of April. It reached Y on 7th of April. Let's write the example again. Okay. Now, X posted the letter on 5th. It reached Y on 7th. Y posted the letter on 8th and it reached X on 10th. I hope you're clear. X gave the offer, but now he wants to call back the offer. So by when can he revoke? By when can he call back the offer? When is X bound by the contract? When is the contract made for X? On 8th of April. So can I say he can call back his offer anytime before 8th? Alright, tell me, when is a contract made for Y? Y gave his acceptance and then he realized that, oh, I didn't want to accept this offer. By when can he revoke? When is contract made for Y? Contract is made on 10th. So can I say he can revoke anytime before 10th? Let's take down notes. So revocation of offer. It can happen anytime before 8th. That is anytime before X is bound by the offer. Anytime before X, before a contract is made for X. Okay, let's discuss revocation of acceptance. Revocation of acceptance can be any time before 10th of April. Yes, so he can revoke any time before he is bound. So revocation means to call back. We gave the offer, but we realized we didn't want to give the offer. We gave the acceptance and we realized, oh, we didn't want to give the acceptance. So when can we revoke? Any time before we are bound by the contract. Now we were discussing that why two separate dates for both the parties. Why is a contract made for X on 8th and for Y on 10th of April? Why two separate dates? Let's assume that for both the parties, the contract is made on 8th of April. Okay, let's assume that both are bound on 8th of April. Now, X posted the letter of offer on 5th. and he is bound on 8th. It means that in case if he decides to revoke the offer, he can do any time before 8th. So technically he has 6th, 7th, and partly 8th, before the letter is posted by Y, that much time is available. So technically he has 2.5 days to revoke. But I am telling Y that no, as soon as you post your letter of acceptance, you are bound, contract is made. This is unfair. You are allowing X 2.5 days for revocation of his offer, but you are not allowing Y any time for revocation. You are telling him that no, as soon as you post your letter of acceptance, you are bound. This is quite unfair. So we cannot have a contract for both the parties on 8th April. Alright, let's say that both are bound on 10th April. Alright, both are bound on 10th of April. Let's assume that. It means contract is made for both the parties on 10th of April. Okay. Now, if contract is made on 10th of April, it means X can revoke his offer anytime before 10th, anytime before the contract is made for him. He decides to revoke on 9th. But ma'am, Y has already posted his acceptance. How can we allow X to revoke after the letter of acceptance is posted? Yes, we agree that a contract is made on 10, but his offer is accepted. Now it takes 2 days for the post to reach. That is not Y's fault, no? You are allowing X to revoke the offer even after it is accepted. This is not done. A contract is already made for him. So we cannot have both the parties bound on 10th. We can't bind them on 8th. We can't bind them on 10th. So let us have 2 separate dates for both the parties. X, you are bound on 8th. That is when Y posts it. And Y, you are bound by the contract on 10th when the letter reaches X. So now technically Y, you have time for revocation on 8th, 9th, and before it reaches X. So we are allowing both the parties proper time for revocation. 1. Secondly, X, you cannot revoke your offer after the letter of acceptance is posted. Your offer is accepted. Now you cannot revoke. So all the aspects are covered when we have 2 separate dates for both the parties. That is why, students, both are bound on 2 separate dates. Alright. Now let us discuss few more points. It is said that revocation must be by a faster means of communication. Okay, let's write that. Revocation must be by a faster means of communication. Now, if the communication is taking place via letters, okay, let's say it is taking place via letters, and if you revoke via letter, again it is going to be very time consuming. See, X, you have already posted your letter. Then you realize that you want to revoke. Your revocation should reach before Y posts his acceptance. Act fast. Don't use regular post. Revocation must be by a faster means of communication so that it reaches before 8th April. Y, you have posted your letter of acceptance. Now you want to revoke. Try that revocation reaches before 10th, before the letter of acceptance reaches X. So revocation must be by a faster means of communication, because once the letter reaches X, now then you will not be able to revoke. Then for you, acceptance is completed, contract is made. Your revocation should reach before these letters reach. So you have to revoke by a faster means. Now what faster means is available? Like you can use Telegram, but that service has been stopped by the post department. Nobody is using. I'm not talking about the Telegram app. I'm talking about the postal services. They also had Telegram. You must have seen in movies, Tar aaya hai. What is the meaning of Tar? It means Telegram. That shows urgency. So now Telegram service has been stopped by the post department. So you can send by speed post, registered post. You can call that person. Okay, so do try revocation, which is by a faster means of communication. Ma'am, we did that. But you know what happened? Y posted the letter of acceptance, then he posted revocation. Both the letters and that speed post, they reached at the same time. Let's consider that scenario. It is such a filmy situation. Y posted the letter of acceptance and then he sent a speed post of revocation, but both reached at the same time. Then in that case, law says whether a contract is made or not depends upon whichever is opened first. So let's say that X opened the revocation first, because see, logically speaking, a rational person will open the speed post, registered post first, because it shows urgency. Now, if you receive a telegram and you receive a normal letter, automatically your mind will say, what was the urgency that a telegram was sent? So a normal rational person will open the telegram, speed post, registered post first, because it shows urgency. So if X opens the revocation letter first, then the acceptance is revoked, contract is not made. But he's a foolish person. He opened the letter of acceptance first. Then a valid contract is concluded. The revocation has no use. It is void in that case. Okay. Now we will write down, if the letter of acceptance or offer and revocation reaches at the same time. Okay. If the letter of acceptance or offer and revocation, it reaches at the same time, then whether a contract is made or not depends on whichever letter is opened first. If revocation is opened first, then that offer or acceptance stands revoked. However, if letter of offer or acceptance is opened first, then a contract is concluded. Okay. It depends on the situation. Huh? It depends. If the letter is open, let's say letter of acceptance we will write, because if the so if the revocation is opened first, then offer or acceptance stands revoked. If the letter of offer reaches, then that offer is valid. If acceptance letter reaches, and then a contract is if that is opened, then a contract is concluded. All right. So it depends on whichever letter is opened first. I would like to discuss one more point with you students, and then we will start reading it from the textbook. Y posted his letter of acceptance, but it got lost in transit. X did not receive it at all. Man, Y posted, right? It means X is bound by the contract. For X, contract is made. But because it got lost in transit, no contract is concluded for Y. Oh, so Y is in a, what should I say, beneficial position. Now he will decide whether he wants to treat this as a valid contract or whether he wants to cancel it. Ma'am, valid or cancel, this is voidable. So in case the letter of acceptance is lost in transit, okay, if the letter is lost in transit, then the contract is voidable at the option of Y. It means Y will decide whether a valid contract is concluded or whether he wants to cancel the contract. Okay, so that call will be taken by Y. So I think he has an upper hand in this case. If the letter is lost, he will decide whether he wants to enforce this contract, whether the valid contract will be made or not, or whether the contract needs to be cancelled. So that option is given to Y. Let us read all this, and while reading, we will also discuss when communication takes place via email, fax, telephone, etc. I hope you have understood the concept well. See, students, this is a very lengthy and slightly tricky concept. If you have understood 60%, I'm very happy with you. Yes, I'm very happy if you have understood 60%, because I'm very sure that when we read and we solve one question, you will be able to understand it 100%. Okay. And if you have understood 100%, I'm so proud of you. Now, communication of offer is complete. Please highlight along with me when it comes to the knowledge of the person to whom it is made. That is when the letter reaches the offeree. So what I have done, I have written the technical sentence and I have also written something which will simplify it. Okay. So when the letter reaches the offeree, X offers to sell his flat. He sends the letter on 5th. It reaches Y on 7th. So can you say when is the offer communicated? Can you answer it? Yes, it is communicated on 7th. The communication of offer is complete on 7th. Now let us discuss. Okay. Mere receiving the letter is not sufficient. The person should also read it. It should come to his knowledge. Please highlight this in red, because you know, one day before the exam, we may skip this, but I want you to read it and then go for the exam. Mere receiving the letter is not sufficient. The offeree must also read it. Mere receiving is not sufficient. Offeree must also read the message. He must have knowledge of the message. Now, X offers to sell his flat. He posted the letter on 5th. It reached Y on 7th. But Y reads it on 8th. So when can we say that the offer is communicated? Offer is communicated on 8th. Communication of acceptance as against the offerer is complete when Y posts the letter. When he puts it in the course of transmission, the offerer or proposer becomes bound as soon as a, please highlight, properly addressed, stamped letter of acceptance is put in the course of transmission. So let's say that X offered to sell his flat to Y. For X, a contract is made, offer is accepted when Y posts the letter of acceptance. Okay, when he posts the letter, but this letter should be properly addressed and it should be properly stamped. Ma'am, he had stamped the letter, address was also correct, but X did not receive that letter. Can you blame Y for it? No, we can't blame Y. Another situation, please pay attention. Y wrote the wrong address and it was not either stamped properly. Then can we blame Y? Yes, he is liable. Another situation. X gave wrong address. Instead of writing A wing, he wrote B wing. Y posted the letter. Can you blame Y in this case if the letter got lost? X is responsible. Okay. Now, if the letter is lost, offerer or proposer is bound if Y decides. Okay, contract is voidable at his option. So if he decides I want to treat it as valid, then a valid contract is concluded. Offerer or proposer is bound even if the letter is lost, because for him the contract is made as soon as Y posted the letter. Then ultimately whether a contract will be made or not, that is decided by Y. Man, what does it actually mean when we say that offerer or proposer is bound? It simply means that his offer is now accepted, which indicates that please don't offer to sell this flat to someone else. Y has posted the letter, your offer is accepted, don't give the same offer to someone else. Now, whether a contract is complete or not, that will depend on why, because the letter is lost, so contract becomes voidable at his option. Okay, this is the same example that we discussed. In case the letter gets lost or there is some delay, what is the position of the offerer? See, for the offerer, once the letter is posted, contract is made. So offerer is bound by the acceptance. The moment the letter of acceptance is posted, he is bound even if the letter is delayed, wrongly delivered, lost by the fault of the post. But if I want to bind the offerer, we should post the letter properly. Okay, so offerer will be bound only when the letter of acceptance is correctly addressed, properly stamped, and actually posted. Okay, Y cannot say, no, I posted the letter, but there is no proof only of him posting it. I mean, how come there is a proof of posting? See, whenever we post the letter, no, the post office will put a stamp with the date that this is the date on which the letter was posted. And when it is received by the post office of the receiver, there also it is stamped that this date we received. So it is possible for us to calculate the dates. It is possible for us to know when the letter was posted, when it was, because there is a proper stamping by the postal department. What is the position of the acceptor? Acceptor he is having an upper hand. Okay, acceptor, he is not bound by the letter of acceptance until it reaches the offerer. Until the letter reaches the offerer, the contract remains voidable at the option of the acceptor. He can decide whether to cancel the contract by revoking his acceptance or to compel the offerer to enforce the contract. So he can either cancel it or he can enforce it. The acceptor is at advantage if the letter is lost because he will decide whether a contract is made or not. Let us now discuss contracts over telephone, telex, fax, email. Did you notice that these are all electronic modes? Yes, they are very different from letter. Here electronic modes are involved. Now, pay attention. The case law, Entoris versus Miles Far East Corporation. I have converted this now into an example. The example that we discussed is that case law only. Okay. Let's say that X calls Y on telephone and he gives an offer to sell his flat. Arey, listen, why? Do you want to buy my flat? The offer was heard by Y. Okay, he hears it. Now Y is replying, yes, but the line went blank. Okay, so he said yes, but the line went blank. So X did not hear Y's acceptance. If we follow the same rules that we studied for letters, if the same rule is followed, then as soon as Y sends his acceptance, X is bound if we apply the same rule. But don't you think that this is unfair? Although he said yes, but X did not hear it. It is highly possible that he will think maybe Y got angry. Let it be. I will call someone else. And then the flat will be sold and there will be a dispute. A huge dispute is possible. And this can be repeated because we know how the telephone department works. There is a lot of call drop, etc. Not in mobiles, okay? But yes, it happens like, I was entering a tunnel and then Y said yes, I did not hear it. I thought maybe Y hung up the phone, he's angry with me. And then I gave the offer to someone else. There are a lot of chances of such kind of disputes arising in the court. So we say you cannot follow the same rule that is applicable to letters. The rule says that now contract will be made for both the parties when X actually hears the message. Okay. So in this case, the contract will be made for both parties. Contract for both parties will be made when X actually hears the message. So rules are slightly different for telephone, fax, email. It has happened with me so many times that I send an email, but the other person says, ma'am, I did not receive it only. Or the student has sent the queries. Okay, they sometimes send doubts on email, and I don't reply because I have not received that email, and they say, ma'am, you don't reply, but I have not received the email. So it happens. Acha, it has happened with me that I have sent email to a student, but his inbox is full. So the email comes, it is bounced back. So we cannot trust these electronic mediums of communication. But yeah, the law trusts post department, that letter will reach only. But here they say, no, rules cannot be the same for electronic medium, because what if you don't receive? What if the line goes blank? What if he doesn't receive the email, his inbox is full? So contract will be made for both the parties only when the offerer hears the message or he receives the email from Y. So contract is made for both the parties on one date only. In case of contracts over telephone, telex, fax, email, the contract will be complete only when the acceptance is received by the proposer and not when it is transmitted by the acceptor. So contract is made only when it is received by the proposer and not when it is posted or put in the course of transmission by the acceptor. If the acceptance is not communicated to the offerer because telephone line goes dead, there will be no contract. Therefore, offeree must ensure that his acceptance is received, that is heard and understood by the offerer. Otherwise, there will be no contact, there will be no binding contract. And it is very easy to judge because the other party always has some words, yes, no, okay. You know, when there is a conversation, after a few seconds, you come to know that the line went blank or dead. Like you are talking to your friend and you are talking, and then, you know, there's a small pause. You say hello because you doubt whether that person is still there or not. So whenever there is a small gap, you come to know, no, that the line has gone blank or not. Yes. So it is possible for us to know whether the other person has heard my message or not, whether it is understood by him or not. And also it is very logical that person will never end the conversation as it is. There will always be some closing. Okay, bye and all. Yes. So it is very easy for us to know whether the person is online or, you know, whether it is cancelled, there is a call drop or not. Still not feeling so well. Okay. Then we have revocation, which you can study later. Communication of revocation is complete as against the person who makes it when he puts it in the course of transmission, and as against the person to whom it is made when he comes to his knowledge. Now, X proposes to sell his car to Y. X revokes the offer by speed post. If X revokes it by speed post, revocation of revocation of offer is complete for X. See, the person who revokes it, for him it is complete when he posts it. I have posted revocation. For me, the offer is revoked. And for Y, it will be when he receives the revocation. Not important for exam. Y revokes his acceptance. When he posts his revocation, for him revocation is complete. And for X, it will be complete when he receives the letter of revocation. Simultaneous, this is important for case-based question. In case the letter of acceptance and communication of revocation, they are delivered at the same time, then whether a contract is concluded or not is a matter of chance. It's a matter of chance. It depends on whichever letter is opened first. Yes. If the offerer reads the letter of acceptance first, then a contract is made. But logically speaking, nobody will read that first. They will always read the urgent message first. But if he reads the revocation first, then there is no contract. So we don't know whether a contract will be made or not. That is why these are known as accidental form of contracts. Depends on whichever letter is opened first. Here students always ask me, ma'am, how will they prove that I opened? Now, what if people are lying? It is a very logical doubt. What if I opened the letter of revocation first, but then I lie and say, no, I opened the letter of acceptance first. See, we have no control over people lying in the court of law. But you are under an oath. हम जो बोलेंगे सच के सिवा कुछ नहीं बोलेंगे. So when you are under an oath, law doesn't assume that you lie. See, if you're lying, then accordingly the contract will be, the judgment will be made accordingly. But we have no control over it. But we don't assume that people will come to the court of law and lie. Also, there are witnesses. Like, you can say, no, no, my servant was standing over there. He saw, I opened the letter of offer first. I opened the letter of acceptance first. He's a witness. Ma'am, if the witness is lying, then the witness will be punished if it is found that he is lying. So we have no control over people lying in the court of law. Okay. But yes, we don't assume that the people will come and lie. All right. So students, with this, we come to an end of our discussion. There is one small part which is remaining, and I had mentioned this earlier, that there are 2 case laws which I need to discuss. That is why I will be covering this concept separately. So in my next session, I will complete this concept, and please be ready with the questions. Yes, go through the compiler and revise all these concepts first. Don't be in a hurry to complete the portion. Simultaneous revision is very important. So what you will do now, you will revise whatever we have studied till now. Okay, watch the next session, and then after that revise everything and be ready when we discuss the compiler questions. Okay, will you do that for me? Okay, so revise everything properly. Keep revising, keep reading, keep revisiting whatever we have studied till now. Read the textbook again and again, multiple times. Try to learn it, and I'm sure after doing all this, law will become your favorite subject. So students, I take your leave, and in my next session, I will discuss communication of special terms in the contract.